by that NGO. It is not your case that he has made any allegation. It is also not a case that CIArb is related to the JBA. That's not even your case. Admittedly, this position are very clear. That neither he has made a complaint against the farm, nor he is associated with the JBA. A third party makes a complaint about you, which has nothing to do with the JBA, unless you allege that, and there is no evidence on the record in the JBA that they are hand in glove. So, even it's not even your case. And if you are citing the court or the judgment of the first high court, the judgment of the Supreme Court in Mohan Reddy versus Union of India, that's old judgment 99, court says that the allegation should not be trivial. It should not be, the test is that whether a third party, third person will, in circumstance, will find that the appointment is suspect, which you think is correct or not?
Your Lordship, if I may answer the Lordship.
Please.
Your Lordship, ICAM is being directly involved in this present matter because of the allegation that are being leveled by ICAM, it actually adversely affected the performance of the respondent to timely deliver.
No,
As a party to the arbitration.
No, ma'am. ICAM is not a party to the arbitration, but it is
expressly is the foundational facts to relate to the mail. What is it? JBA. To suspect the competence of cashier. That is not. What is that? How do you relate? That's what my brother was asking.
Indeed, Mr. Arbitrator, there is a substantial relationship that exists here. First of all, the council would want to contend on how ICAM is related to respondent and this matter, and how appointment of Mr. CIArb would be partial on our basis. Your Lordship, ICAM.
Tell us one thing, whether test should be subjective or objective.
Your Lordship,
To determine whether
Your Lordship, the test should be objective, but the threshold.
Yes, this has to be objective.
But the threshold.
How do you tell us, how do you convince that the mayor speaking assignment for this NGO would constitute bias?
Your Lordship, when we talk about the test of the threshold for the bias, that is the reasonable apprehension in the mind of the party. Your Lordship, I would like to refer to page 15 of our Moot memorial.
Is it only apprehension, or it should be is actual bias, real bias on objective test?
Your Lordship, the word that has been used is reasonable bias in the mind of the party, and it has been upheld through the judgment that an arbitrator should look at the circumstances not with his mindset but rather from the mindset of a party. And if we look at the present circumstances from a reasonable person mindset, there are justifiable and
So should we
rational
take it then that anybody going and speaking in a particular merely because he gave lecture in a particular, even a speech in a particular, does it mean that it will constitute?
Your Lordship, it has been made strong opinion and specifically on the fraud allegation, specifically in the healthcare and pharmaceutical sectors.
That is the answer.
Yes, Your Lordship. So there is a bias in the mind of Mr. Arbitrator, and he failed his duty to disclose such circumstances at
Has
the
he raised
very
any particular allegations against you in that speech?
No, Your Lordship. The Moot proposition is silent on that, but he have expressed that the parties who are involved in
Yes,
fraud.
express is generally what is being followed in the pharmaceutical industry. How to link with you? We assume that the link, your assumption that it is directly or indirectly an accusation against you. That's your assumption, right?
No, Your Lordship. Your Lordship, if we clearly look at the clarification number 21, it has been stated there that he has expressed his strong opinion to penalize the party who are involved in fraud allegations.
If you are not involved in, why do you worry about it?
Your Lordship, that exactly brings us to a second issue, that is the jurisdiction
Are
about
you
fraud.
saying that he has a bias against the whole pharma industries and therefore he should be out?
And
So
this-
category of kind of disparagement.
And is
It's
this
not
waivable or
sensitive.
not? Is this waivable or not?
Ms.
Is
Abhay.
it waivable or not?
No, there are certain
that?
situations where parties, despite there being existence of a particular reason, one can waive that. This is what is being asked.
Is it waivable or not?
Can
Not
it be
waivable.
waived?
Ma'am, in this present situation, from the respondent side, we contend that this is not waivable. Otherwise, we will be at a very disadvantaged
So according to
position.
you, it falls under the 7th schedule
Schedule 7.
or in IBA guidelines and right list.
Anyway, see,
Then what it is?
your case is itself that he has
Ma'am?
spoke generally against the pharmaceutical business, nothing against particularly about you.
Your Lordship, first of all,
Yes, not
Also,
spoke
he has-
anything against you.
he had not specifically,
Then we overrode your objection on the
first of all, Your Lordship,
Go to
I,
next point.
Next point, please, move on.
if I may just answer to that question.
In your submissions, you have not referred to this Postelpine chairman case. Are you aware of that?
Yes, Lordship, we are aware of that.
Have
We
you
are not-
mentioned in your submissions? Are you relying on that?
Indeed, Your Lordship, in para 1.4.4, in that particular case, the law commission report was taken into consideration, delivering the intent of the legislature.
How it's applicable to you?
And if Mr. Kashyap is a man of integrity or not, as you have mentioned Halliburton versus Chubb.
Ms. Abhay, yeah.
You have mentioned
Respected
Halliburton
arbitration.
versus Chubb in your case. So there are also the similar circumstances, but he was considered to be non-biased because of the man of integrity. So you are challenging his integrity also, Mr. Kashyap. Because you have mentioned this case.
First of all, respected arbitrators, we have not relied on IBA guidelines because that is non-enforceable in present matter. And the present matter does not go under Schedule 7. It goes under Schedule 5 as
And
it
then
talks
it is
about.
waivable. It can be waivable. It is not rendering arbitrators an impossible. That is one thing. Second thing is you have mentioned Halliburton versus Chubb. In Halliburton versus, despite of that the person was involved in the case, he was held to be non-biased because he was man of integrity. So that means if suppose you are following that case law, you are following that principle, that means you are challenging this person is not the person of integrity.
Ms. Arbitrator, we have quoted that case because I agree that there are factual differences in the present matter.
I am talking in principle. Whatever the facts, different. But in principle, that case, if you are following, that means you are challenging the personal integrity, and that is also overruled in that case. In Halliburton versus Chubb.
That's why this has to be considered. So that in a particular case, it is really in a situation of emergency.
If I may refer to compendium.
Yes, we can.
Please sit down. Please sit down. Please sit down. Please sit down.
Do not disturb the court proceedings.
Please sit down.
Everyone, please sit down. Settle down.
Settle down. Please proceed. The Lordship, we have quoted Halliburton case with respect to the allegation. You please proceed. Don't disturb the court proceedings. Please proceed.
You can proceed.
We have quoted the Halliburton case with
How much time is necessary? 13 seconds. We are not going to the second point. You are addressing the second point, right? Counsel?
Other points, not much
Yeah.
time.
Second issue.
Second law.
Please address that.
The second issue is, Your Lordship, the second issue is that the present matter does not fall under the jurisdiction of this honorable tribunal. Since the fraud allegations that have been involved in the present case are of very serious nature.
Fraud allegation.
Your Lordship, that has been stated in para 9 of the Moot proposition. We are being alleged of manufacturing and distribution of drugs, we are being alleged that we have produced a drug that which do not meet. We have tempered the standard of quality result, as well as we are being alleged of furnishing falsified documents to grant the approvals from the
That is
regulator.
only subject of the contract, not a contract itself is not a question. Subject of the contract contract, it's a possibly there is, you might have done mistake. In that subjective contract, if the fraud allegations have been brought, it's only a matter of evidence. So why the tribunal is not competent to decide such issue? It's a matter of evidence and depreciation. The question of the fraud in the contract and fraud of subject of some of the transactions are related. Both are different. In what circumstances we both dissuade a tribunal from entertaining such disputes?
If I may speak. Your Lordship, the first contention is that the fraud allegation are inextricable part of the present contract. Because of the fraud allegation, there were regulatory bodies that conducted investigation against us. The regulatory body
There is no fraud against the contract itself, which contains the arbitration agreement. Absolutely, there is no allegations of fraud.
Your Lordship, when we are being alleged of producing the medicines that are of low quality, that directly goes to the contracting the law provision under the Drug and Cosmetic Act. If we are being alleged that we have tempered the quality results of the medicine that we are producing, so that means that we are producing medicines which are of low quality and that does not meet the
That's only aspect of the association of evidence.
And there is no report. A parallel proceeding can go on. If you suppose you have done wrong things, you will be charged under the of the DNC Act, and parallel proceeding, same proceeding can go on.
Your Lordship, but the kind of fraud allegations that are being levied against us, they expressly
No,
constitute
what
criminal offense.
circumstances a tribunal cannot entertain when there is allegation of fraud?
Your Lordship, if I may refer to Ayyasamy versus A. Parvasivam case that differentiated between complex fraud and simple fraud, the criteria for determining complex fraud is that their fraud allegation should permeate the whole contract in such a way that it renders the contract to be void, and the second is,
Exactly.
Your Lordship,
You mean to say the contract is void here?
indeed, Your Lordship, because when the core consideration of our contract, the supply chain agreement, was delivery of essential quality
There is
medicine.
no dispute in regard to the contract.
Your
It's
Lordship,
only in regard to the dispute is in regard to performance of terms and conditions in the contract. What are
Counsel, you are
the?
exceeding your time limit.
Yes.
Is it your case that they misrepresented the facts? They had fraudulently obtained the quality assurance certificates.
Your Lordship, we are the ones who are delivering the medicines and we are being alleged of these facts. But from the very first stance, we have stated that we are not involved in any kind of these fraud allegations. But since the fraud allegations that are being levied against us, they directly hit the core consideration. That is our medicine, the medicine that we are producing being alleged.
That's what we are asking here now on the question of jurisdiction. When the tribunal ceases to have an authority of decide dispute, when there is allegation of fraud.
Your Lordship,
Only one
moreover,
circumstance. What is the circumstances?
Your Lordship, the second stand is the matter fall into the public domain, which is exactly the matter at the present case. Because the pharmaceutical matter, we are producing medicine at a very larger rate and it impacts the public at large. So while we have fraud allegation against us, which expressly constitute fraud allegation, because when we are being alleged of furnishing false documents for granting the regulatory approvals, which means that we are being alleged of forgery, and also inclusion of anti-corruption bureau into the investigation process, that our investigation
You
that is
want arbitration or not?
Your Lordship, we want arbitration, but the present tribunal.
You don't want them to conduct.
See, there is a region here. Can a party against whom fraud is released be allowed to come to the tribunal or to the court to say that since there are allegations against me, therefore let there be no arbitration? Can it be argued?
So just to add on that, are you supporting this fraud allegation? Yes.
Against you.
No, Your Lordship, from the
If you are
very
not supporting the fraud allegation, then you are basically trying to take advantage of their allegation to get rid of this situation.
Your Lordship, when we are being alleged of such serious fraud
Yes,
allegations,
but you are not supporting
Suppose
that.
they are supposed to deliver certain qualities of medicine, and instead of it deliver various medicine. You mean to say that tribunal cannot adjudicate that dispute
Your Lordship,
because
that depends on a different factual ground.
that's what we are asking. What basis a fraud allegation would affect the power authority of the tribunal?
Your Lordship, in the present case, the fraud allegation qualify as the complex one, since they directly hit at the very root cause of the supply chain agreement, because directly the fraud allegation are based on the core consideration of the agreement between the claimant and the supplier.
Do they have any pecuniary claim against you on the ground that your ex was a
Your Lordship, when they are claiming under
answer is no. If there is no pecuniary claim, monetary claim against you on this fraud,
Your Lordship, under issue 5, they are claiming compensation for on the basis of delayed delivery and fraud allegations. So since they are involving fraud allegations,
there is no pecuniary claim on the basis that you fraudulently obtained that.
Fraud is linked with the reputational part. Not pecuniary.
but Your Lordship, fraud allegations have adversely impacted the respondent's performance, and that
There is
has
no counterclaim from you.
Is it counter claim? That's what I wanted.
There is no contact.
Is there any counter claim?
No.
with respect.
Against the JV.
Do you have any pecuniary claim against others?
Your Lordship, that has been stated in our prayer.
Suppose if the termination of this contract,
We have no counterclaim from the compensation, but we have denied that we should not be held liable for granting compensation for such an event which has not been yet.
Yes, you can conclude.
Your Lordship, it is humbly submitted that the present tribunal lacks jurisdiction since the serious fraud allegations are being involved,
Yes.
as it falls into it expressly constitutes criminal offences against us, and it directly strike at the very root cause of our
Yes,
supply chain agreement.
Thank you.
I may call my co-counsel.
Thank you.
Council seeks permission to
Yeah.
open for that. Respected arbitrators, I would be addressing the third, fourth and the fifth issues. The third issue is whether the claim for USD 30 million towards the cost in sourcing alternative medications is recoverable. Now, our first submission is that the delayed deliveries are exempted by the force majeure clause. So it must be appreciated.
What is the force majeure here?
I apologize. Mr.
What is the force majeure event here?
The force majeure event here is unforeseen logistical challenges such as port congestion and increased demand for shipping services at a global level.
Will it constitute a force majeure?
Indeed, my lordship, because there is a specific force majeure clause in this contract, if I am permitted to.
What is a force majeure?
A force majeure refers to an event under which a party's liability to perform the contract and the liability to pay damages for any loss arising out of the non-performance is exempted. In this particular case, there is a specific clause in the supply chain agreement
when
which
did you invoke this force majeure? When did you send a notice of force majeure?
I would like to pass on a list of dates that we have prepared for the convenience of the
Date.
Yeah, we cited it on, we sent a legal notice dated 15 June 2024 in which we claimed that the delayed deliveries are exempted by the force majeure clause.
Before arbitration and after arbitration.
That was before the arbitration had been instituted. Now, since there is a specific force majeure clause, and if I am allowed to refer to that particular clause, I would like to read that. It is on the last page of the proposition, the second last clause. The agreement includes a force majeure clause to address unforeseen events beyond the control of either party, such as natural disasters, political instability, or significant disruptions to global supply chain. So significant disruptions to global supply chain have expressly been included under the force majeure clause in the contract, and the agreement has been drafted with the consent of both the parties.
The question is whether there was significant change. That was being asked.
Indeed, Mr. Arbitrator, the disruptions that were there were of significant nature and were at a global level, which is reflected from the Moot proposition. I would like to rely upon the relevant paragraph. It is paragraph number 8. It reads that the global demand for shipping services had surged. Therefore, the demand
Merely because there is a surge.
there are more factors as well. This lead to a shortage of available transport vessels and increased competition for shipping slots. Big Firm faced difficulties in securing timely shipments for its duct, resulting in leakage. Further, major ports experienced significant congestion due to increased cargo volumes and operational inefficiencies. These delays led to prolonged waiting times for the vessels to dock.
That constitutes force majeure? Merely because there is a surge and there was a huge demand for the logistics because of its
Mr.
demand.
Arbitrator, these circumstances squarely fall within the term significant disruptions to the global supply chain as has been used in the force majeure clause in the contract.
How do you say that? That is the question.
Because paragraph 8 makes it evidence that these difficulties that were there were at a global scale, and it is also pertinent to point out that we took all mitigation measures in accordance with the force majeure clause. We explored alternative suppliers. In fact, out of our commitment towards the cause of serving public health, we went above and beyond our call of duty, and we made additional significant expenditures, and we made more expedited shipping services. We further expedited our internal processes, but due to these circumstances were there at a global scale, and most of the transport routes were affected, it was not possible for us to have met the delivery schedule despite our best efforts. So for events beyond our
So have
control,
you invoked the force majeure condition at a time when you found surgery in the shipping services?
Ms. Arbitrator, we informed the claimants of the potential delays even before the
It's
delay.
not about the potential delay. Force majeure is a contractual term or contractual provision which has to be invoked, which has some law to invoke. So did you invoke that at the appropriate time?
Indeed, Ms. Arbitrator, we invoked the force majeure clause in our legal notice dated 15 June 2024 in reply to the claimant's legal notice.
No, I'm asking about that it was done at a surge in shipping services. So that time only I wanted to know.
The time was January 2024. The disruption started from January 2024.
We informed other side.
The paragraph 11 of the proposition makes it clear that as soon as potential delays were identified, we communicated them with the claimant well in advance. And therefore they could have taken mitigation measures to make alternative medications, but despite having ample opportunity and time to do so, they failed to do so. We will come more on mitigation measures in the next argument.
So tell me one thing. When you are a supplier, you're either owner of the formulation or in contract manufacturing. There's a concept of the supply chain resilience. When you are aware that they are heavily reliant upon you, and in fact they after a year they completely shifted all the supply to you. You could foresee that there can be some situation where that logistic problem may come, and then the supply will be disrupted. Did you make any efforts to put some process in place to mitigate before it actually started?
Mr. Arbitrator, we in fact identified the issues well in advance, and we took all possible measures to mitigate the impact of those events as is evidenced from paragraph number 11 of the proposition. I would like to rely upon paragraph 11. It reads that VII, that is the respondent, took all reasonable steps to mitigate the impact of the delays on the supply chain and ensure that the disruptions were minimized. VII promptly communicated with JMED regarding the potential delays as soon as the issues were identified. Regular updates were provided with the status of the shipments. VII further explored alternative transport routes and suppliers to expedite shipments and reduce delays. Additional resources were allocated to expedite production and to ensure that quality standards were maintained despite the
That's
disruption.
not my question. The regular update is of no use. I question that not when actually problems started. Then definitely you took steps. But before that, because now you are supplying more, they are totally dependent upon you. So as a supplier, you were not under some, I'm not saying legal, but some obligation to ensure that supply is not disrupted.
Mr.
Your
Arbitrator,
response was post problem started, but not before that.
Mr. Arbitrator, we also took steps to expedite our internal processes, so that though there are external processes, as far as the internal time taken to put the supply chain into process, that can be minimized and it can be reduced to as lesser an extent as possible, so that the overall delivery timeline can be reduced. So we took all possible measures that could have been taken. And despite that, if the delays were not, I would like to rely
If the
on
internal process was compromising with quality standard, then they will be right, saying that you compromise the quality
Mr.
standard.
Arbitrator, with great respect, I'd like to differ. We are not stating that we in any way compromise with the quality standard. We in fact we expedited the process. That does not mean that we compromise with the quality standard. We maintain the quality standards and at the same time we expedited the process. Now, if I'm allowed to proceed to our next argument, is that the delayed deliveries do not constitute a breach as time is not of essence to this particular contract. Now, it is at the very outset, it is pertinent to clarify that the cause of action for the claimants to instituting this arbitrator is merely delayed deliveries, and there is no refusal to deliver or failure to deliver on our part. And it is settled law that a delayed performance of a contract can only be considered as a breach when time is of essence. Now, as per the judgment in Hind Construction versus State of Maharashtra by the Supreme Court, which is there at page number 32 of our
Construction will not help you because in construction there were two clauses which really mattered for the court. One was clause for liquidated damages, another was for extinction of
This is precisely our contention that since the present agreement also involves a contract for extension of time, that is a flexibility clause, this negates any assumption, as has been held in the judgment, this negates any assumption that time could of essence, as the court held that the mere fact that the parties contemplated that there could be delay or there is a scope for extension negates the inherent suggestion to the contrary that time was of essence, and under such circumstances, delay in performance or delayed deliveries cannot constitute a breach, and therefore the claimant have no right to repudiate the contract damages. Now, moving forward to our submission, which is with respect to the claim of USD 30 million, it is submitted that it is an established principle that the contract price can be regarded as the evidence of the prevailing market rate. Now, if the claimant procured alternative medications above and beyond the contract price, it is upon them to substantiate that they feel that they explored reasonable measures, and despite that they could not source more affordable alternatives, because this additional expenditure cannot be recoverable from the respondent due to their own inability to mitigate. And in this case, this additional expenditure stems from the claimant's own inability to mitigate. And therefore, the causal chain between the
who posed the burden to prove on record that market price was no tax, it was tax minus 1. Is it the burden was on you or on me?
Mr. Arbitrator, the court usually takes the evidence of both the parties in this regard. However, as per section 73 of the Contract Act, the onus is upon them to prove that they have taken mitigation measures to remedy any loss causing out of the purported breach. We are not admitting a breach in the
production which you that it was only because of logistics you are not able to supply.
I beg your pardon.
You had a production of this medicine. You had a production.
You had enough material lying in stock you had produced, but because of logistics issue you could not see the supply.
Indeed, Mr. Arbitrator, the majority of the delays stem from due to the supply chain disruptions, which made it impossible for us to ship the.
So you had a raw material. You have a.
Moreover, Mr. Arbitrator, it has also been mentioned that we were facing regulatory investigations, due to which there were process overalls. So, although the Moot proposition is silent on whether or not expressly we had the raw material or not, but
who has to provide logistics has to be arranged by you as per the contract.
but the regulatory challenges affected that, and therefore it was not within our control. And it is not in the proposition whether or not we had the available raw material, so I would not like to comment upon that. But the majority of the delays stem from the delays due to the unforeseen logistical challenges, and therefore due to
in contracts are all about risk education. You take the risk, you have to do it. Unless your case falls squarely within force majeure.
Mr. Arbitrator, as we demonstrated earlier, the case squarely falls within the term significant disruptions to the global supply chain, and therefore the delayed deliveries are exempted by the force majeure clause. Now, moving on to the quantum of damages that we are seeking, when it that the claimants are seeking why they are not recoverable, I would like to proceed with issue 4, which is the alleged loss of USD 10 million towards penalties and fines incurred due to the claimants. Our submission is that these regulatory fines were imposed due to the claimant's own inability to take mitigation measures, because as per the force majeure clause, both parties, including the claimant, was under a duty to mitigate the impact of such events. And I would like to point out that as per clarification 14, there was no exclusivity clause in the present case. Nothing precluded the claimant to procure the medicines from alternative suppliers. Moreover, it is a matter of fact that the claimant had access to other known suppliers from whom they had accessed medicines in the past, as per para 7 of the proposition. It is also a matter of fact that the delays commenced in January 2020 and the notice of termination was submitted in June 2024. Therefore, there was a period of 6 months, and therefore they had ample opportunity to explore other alternative suppliers and to take mitigation measures. So despite having ample opportunity and time, if the claimant failed to take mitigation measures and discharge their duty under section 73 of the Contract Act and under the force majeure clause, the causal chain between the purported breach and the alleged loss has been severed, and such claims cannot be made recoverable from the respondent. Now,
Was there any penalty clause in there?
there was no specifically penalty clause. It was held that the damages would be awarded based on the duration and impact of the delays. So there was specifically no penalty clause.
So general damage.
Indeed, Mr. Arbitrator. Now, moving on to issue 5, we would like to reiterate our submissions with respect to mitigation, failure on part of the claimant to have taken mitigation measures, and with respect to the quantum of compensation they are seeking in issue 5, that is the 15 million for alleged loss and for loss due to the allegations of fraud and delayed deliveries. Firstly, I would like to point out that the allegations of fraud have been leveled by a third party. The third party which has leveled the allegations is not a party to the contract, and therefore there is no breach or nor has there any terms of the contract being violated by leveling these allegations. So as per the principles of contract law, the principles of section 73, such claims cannot be made under contract law.
This argument goes against your own argument in respect of the post speaker that this arbitrator, the tribunal does not have the jurisdiction because on account of fraud, because this has been raised by somebody else.
Mr. Arbitrator, we are, as per the law, we are allowed to take alternative pleadings as long as they are not
restrictive.
because these pleadings are not mutually destructive. It would only be regarded as mutually destructive if they cannot be true at the same time. However, these can be true, then these are merely alternative pleadings which should be permitted, Mr. Arbitrator. Now, as far as the delayed deliveries are concerned, they stem from their own inability to mitigate, and there have been instances where the courts have, for instance, I would like to rely upon the judgment in ABS Marine versus Indian Bank, wherein similarly the claimant was seeking compensation for reputational loss. But the Supreme Court held that since the claimant failed to take alternative finances, in this case this was a loan agreement, since the claimant failed to explore alternative finances, they cannot now say that the reputational loss that has occurred, if at all it has occurred, was due to the acts of the respondent. Similarly, in this case, due to an absence of exclusivity clause, if any loss of reputation has occurred, it is solely due to the claimant's inability to mitigate. Moreover, Your Lordship, Mr. Arbitrators, I would like to point out that the claimants are plucking out this arbitrary figure of USD $15 million out of thin air. There is no basis on which they are substantiating their claim. And in Mecca-Medi versus Flowell Hydro, it has been held that such claims must be outrightly rejected. I would like to rely upon the relevant para. It starts at page number 46 of the compendium. If I am allowed to refer to.
Counsel, you are exceeding the time limit.
So you can leave it.
I would just conclude it that since the claim is unsubstantiated by evidence in view of the judgments in Mecca-Medi versus Flowell Hydro and BNK Hospitality versus Youth Center, their claims must be outrightly rejected. If the learned arbitrators are satisfied, may I proceed with the prayer? Please. Wherefore, it is most respectfully prayed that this honorable tribunal may be graciously be pleased to A. Allow the respondent's application challenging the appointment of Mr. Kashyap and set aside his appointment. B. Uphold the respondent's challenge to the jurisdiction of this honorable tribunal and dismiss the arbitral proceedings as non-maintainable. C. Reject in entirety the claimant's claim for USD 30 million towards the cost of procuring alternative medications. D. Reject in entirety the claimant's claim for USD 10 million towards penalties and fines. E. Reject in entirety the claimant's claim for USD 15 million towards alleged reputational loss. And F. Pass any such further orders or directions as this honorable tribunal may deem fit and proper in the facts and circumstances of the present case and in the interest of justice. And for this act of kindness, the humble respondent, as in duty bound, shall ever pray. It was an
not
honor.
possible for us to grant all prayers system. Which one am I going to choose? That is just, I think I said the point of cashier or or the last one. Anyway.
Look, prayer is made with respect to all the race lords. Now it is up to the tribunal which wants to grant. It was indeed an honor arguing before this honorable tribunal. We are grateful. Much obliged.
You leave it to- Right, you give 2 minutes. Yeah. The court master is quite strict.
Due to paucity of time, there are shortly 2 rebuttals that I am putting forward. The first being that the major concern, the major excuse for the delays that have been made by the respondents is logistical challenges, which has been given as by their arguments. Also, sir, at the same time, it is important to mention as per the Moot proposition, the respondent has received global prestigious awards for the commitment of regular shipments during the COVID era. As per the understanding of the counsel for the claimants, COVID is one of the greatest and the most hardship-filled time in the last century, in which nearly everybody faced logistical challenges, and the respondents defeated that with their hard work and consistency in delivery shipments. So the first question is that if they could have, through the mitigation steps, mitigated such a big pandemic, how could they not mitigate small challenges in logistical and the shipments?
Now, you
But
want
you
to
have
know,
one
you want one ask questions.
Yes.
You have a source from alternative places.
Yes.
What are the logistics for that?
Sorry, sir.
You source from some other alternative company.
Yes.
So what were the logistics used for that?
So the same ports and other routes
So
have
you
been.
never raised that point.
So because the Moot proposition has been silent, we can't receive on
And insofar as there was no exclusive clause,
Yes, sir.
so you should have arranged for some alternative clause. You have 1 month, complete 1 month, they give you the notice.
Sir, I
So the
agree.
point is that if you have sourced from other sources, using some other logistics, that would have been a highlight for you.
So that exactly brings to the
Because
contradiction
that
that
will move to the root of their difference.
indeed, sir, that exactly brings us to the point that if we are able to source from other sources, where are the logistical challenges that the respondent was facing? Secondly, the bench comments, the second rebuttal. Much obliged. The second being, in the written submissions, page number 21, if the opposite counsel and the bench may refer, I would like to read it for the bench reference. They have quoted the just an extension.
Yes.
There is submission?
No, sir, the submission of the respondent.
Yes.
Page number 21 of the submissions, para 3.112. Also, the conduct of claimants claiming compensation of USD 15 million for loss of reputation because of delayed delivery and allegations of fraud shows that they believe in the existence of allegations against the respondent. Sir, the contention here is that what we are arguing is that because of their loss and because of the fraud allegations that they have on them, our reputation was put at stake. This is clearly visible on page 13 of the Moot proposition, wherein it is said that our patients begin to lose trust in us because of them. So that is the contention which I feel is misled in their arguments.
Thank you.
Thank you.
If I may be terminated.
1 minute.
Learned arbitrators, I would like to point out that the circumstances that were there in the COVID-19 era were drastically different from the circumstances herein, because at this instance we were also facing regulatory investigations in addition to the supply chain disruptions. And the supply chain disruptions were of much greater magnitude. And in the COVID-19 era, the supply of essential medications were prioritized, and the government guidelines were there which made delivery of vaccines and other essential medications on a priority basis. But however, there was no such medical emergency during these circumstances, and there was no priority given to the supply of medications per se. And secondly, I would like to point out that the judgments relied upon the claimant with respect to the force majeure are mostly dealing with section 56 of the contract, which deal with the principle of frustration deholds the contract. However, where there is a specific force majeure clause in the contract, the principles of section 32 of the Contract Act would apply, and when section 32 comes into place, what is to be regarded is the terms of the contract. And in the present case, the terms of the contract expressly include significant disruptions to the global supply chain. And the circumstances in the present case palpably fall within this description, and therefore the delayed deliveries are exempted by the force majeure clause. That will be all from my side. Much obliged.
Blank and black. I thought some.